Okay, Mr. Raskin is recognized.
Could Ms. Scanlon go before me? And we switch?
Ms. Scanlon is recognized.
Thank you so much. You know, as more of our lives shift online, obviously robust digital privacy protections become more and more important. And the immense catch of digital data that we each generate by carrying one or two smartphones or whatever, it becomes really staggering. Obviously, we've got to catch up some. And it seems as though the Supreme Court's kind of narrow and antiquated, possibly, interpretation of personal privacy rights is not meeting this moment. So I had a couple questions. Ms. Goyton, is it? The Fourth Amendment guards against unreasonable searches and seizures. And it's been interpreted by the Supreme Court in Katz to include a reasonable expectation of privacy. Do you think that Americans still have a reasonable expectation of privacy in their online browsing and cellular phone use when we hold that up against the Katz decision?
They absolutely do have a reasonable expectation of privacy. Whether the court will acknowledge that they have that expectation and honor it is the question that I think we're all asking. As I mentioned in my opening remarks, the Supreme Court has begun to catch up. And the fact that the court recognized that people have a reasonable expectation of privacy in their cell phone location information, even though they, quote unquote, share that information voluntarily with the phone company, that is a major step forward, because it means that even when information is stored by a third party, highly, highly sensitive information, the court might still be willing to give it protection. Unfortunately, the court very explicitly limited its holding in that case, Carpenter versus the United States, to the facts of that case, to historical cell phone location information collected by the police. And it could be years before the court looks at, say, web browsing history or DNA or communications metadata. Each kind of information, each technique by which it's collected and stored, each kind of company that stores it and shares it is going to be a different use case, a different fact pattern that comes before the court, and it's going to take years. Americans' Fourth Amendment rights should not hang in the balance during that period. That's why it's so important for Congress to step in and fill that gap.
Yeah, it's certainly something. You've raised several issues. First of all, this idea that we voluntarily turn over this data when it's voluntary. If you want to use the service, you end up forfeiting a lot of this data. So what can we do? I mean, we're in a situation where there are any number of things we would like Congress to pick up the ball and enact legislation, if we can get our Senate colleagues to go along. What do you suggest we do?
I think there's been broad bipartisan consensus here today among the witnesses and among the members that the Fourth Amendment is not for sale act is an important measure and that it should be passed quickly. What that law will do is it will close some of the gaps that technology has opened up in the Electronic Communications Privacy Act and also the Foreign Intelligence Surveillance Act. So it will plug the gaps in existing laws that are allowing the government to evade those laws. That's something that can be done quickly and in a very straightforward way. At the same time, I think there's also been fairly broad agreement that it would behoove Congress to undertake comprehensive data privacy legislation. That's a big project, but Congress should throw itself into that effort.
Thank you. Professor Wexler, we've heard a lot of concerns raised recently with the abortion bans that are going into effect in some states about how data could be used to track women's travel or attempted access to reproductive health care. Can you talk about how that relates to our hearing today with respect to concerns about law enforcement using data and how that compares to other criminal prosecutions?
Absolutely. Thank you for the question. It's a real concern. There's been a lot of discussion about period tracking apps and other reproductive health apps, and those do put pregnant people seeking medical care at risk. But it's not only those apps. It's location information, it's web search history information, it's chat messages, text messages, unencrypted chat messages have already been used to charge one woman who was miscarried with feticide and another with murder. So the discussions the committee is having now on data privacy are all the more urgent post-Dobbs, but I would urge the committee not to stop at the Fourth Amendment is Not for Sale Act or at a privacy statute, but enact an evidentiary privilege that would block federal and law enforcement access, as well as civil litigant access. Thank you.
Thank you. And I yield back.